Welcome to Strategic Justice in Action with David Senoff.
Hey everybody, welcome back to an all-new episode of Strategic Justice in Action with David Senoff. I'm your host, Mike Leon. David here is the founding partner of First Law Strategy Group, where he focuses on appellate advocacy, insurance bad faith, and public policy litigation. He's got nearly 3 decades of experience, and he also represents candidates, political parties, PACs, in navigating the complex rules that govern campaigns and elections. And in today's episode, we're going to be breaking down the legal framework behind campaigns, elections, and political action committees. David, good to see you as always. I'm very interested in this, as I was telling you off air. So what areas of law fall under campaign and election law?
Hi, Mike. Thanks for having me as usual. And this is a fun topic to discuss, particularly now. So the areas of law that generally fall under campaign and election law are pretty diverse and make for some crazy kind of cases and issues, but it includes whether or not a person has, starting at the beginning, whether or not a person has met all the requirements to be on the ballot for the particular office they're running for. That's the earliest possible case. Then during the campaign, you have all the campaign finance laws, which vary by state if you're running for a state or local office, or if you're running for a federal office or controlled by federal statutes. During the campaign, you can have potential libel and slander claims against your opponent, First Amendment claims. As it gets closer and closer in time, particularly as related to campaign literature or posters, right? There's all kinds of rules and regulations about what the posters have to say in terms of who paid for it, where they came from, identifying your campaign committee. And then finally, as you get to the end, and again, remember the whole campaign finance law and set of regulations is running through the entirety of the campaign from the beginning to the end. And then at the end, depending on the result, as we all know, we can have recounts. You can have, you can check machines. You can ask for voter rolls. All different kinds of issues arise at the end of a particular campaign. And then one other thing I will mention is that in a larger scale, something that I know that's been in the news that we argued here in 2022, which is redistricting, that also falls under the general ambit of campaign and election law.
That's right. A lot in the news with California and Texas. I'll leave that there for a sec. Let's come back to what are the main legal requirements here for candidates and political organizations when they need to follow the raising and spending of campaign funds.
So, that really depends on the state that you're in. In Pennsylvania, for example, you, the candidate, can raise and spend unlimited amounts of money so long as the candidate and the candidates committee is not taking any money from corporations. Corporate giving is strictly forbidden, generally. And when I say corporate giving, I mean, XYZ Company Incorporated cannot write a check to your campaign. However, the employees of XYZ Company Incorporated can write a check to your campaign because individuals obviously can write checks. Other than that, in Pennsylvania, there are very few sort of restrictions on giving to, one person giving to another. With regard to organizational giving, right, as I mentioned, the companies can't give, but there are PACs, right? PACs can be set up by individuals for, sort of the long run, like issue-oriented PACs. For example, pro-life, pro-choice PACs can set themselves up, raise money, all the time pretty much, and then give it to whoever they want. They can run ads. They can do whatever they'd like to do with the candidate, but the candidate then has to report on their campaign finance reports that they've received this kind of assistance from PACs. In addition, and I think I forgot to mention, individuals who give money will also be listed on the candidate's campaign finance report, which are publicly filed. So, reporters, individuals, you and I can just go check who gave money to who and how much. The one thing I will say is that a lot of times you have organizations forming what they call a nonprofit, a nonprofit PAC, or a political arm of an already existing charity or nonprofit. And in those cases, the giving is truly restricted to, get out the vote, helping people to register, maybe issue-oriented, more educational, informational ads and written material that doesn't necessarily support one candidate or the other, but gives voters information about legislation or how, if a candidate has been in office for a while and is running for a higher office, how both candidates voted, all of that kind of informational stuff. And finally, there's what everybody calls the dark money or independent expenditure PACs, which are these organizations that go out, raise money, and then use the money to help a particular candidate. And these are not nonprofits. They can be unions. They can be just ad hoc groups that pop up that want to support you for your run. The issue with those is they can raise as much money as they want, in as large amounts as they want, and a lot of times from whomever they want, including corporate money, but they cannot in any way work with the campaign. So, for example, the candidate can't say to the person who's running this independent expenditure organization, hey, it would be great if we could get some negative ads about my opponent. I don't want to put them out because I don't want to seem like I'm going negative. But if, some independent group could do it, that would be great. And what that's called is coordination. And these independent expenditure groups are not allowed to coordinate in a formal manner.
I want to go back to something you said about contributions, especially contribution limits. You kind of explain how this work. How do contribution limits work? And then what mistakes do campaigns frequently make regarding them?
The biggest mistake that campaigns make is that they confuse the federal with the state. So, and even here in Philadelphia, for example, we have city limits depending on what your business is. For example, if you have a contract with the city of Philadelphia, the ethics rules for giving and receiving money are much stricter than if it's just John Q. Public, right, giving a contribution. But the biggest mistake people make is they confuse the federal and the state limits. As I said, here in Pennsylvania, if you're running for a completely state office, let's say you're running for treasurer, there are, as I said, no limits. And the only sort of limitation is that you can't accept corporate funds. On the other hand, if you're running for a federal office, there are limits, and the limits, of course, just went right out of my head, but there's a limit that each individual can give for a primary, and then there's a separate limit that each individual can give for the general election, and that applies equally for their spouses, so that no one person can directly give to a candidate more than the amount, or twice the amount if they're married and it's coming from both the husband and the wife. So it's that confusion permeates a lot of the issues we see with fundraising. And once you get that into your mind, it's easy to keep it separate, but sometimes people just confuse that.
Aside from those limits, what other compliance issues frequently cause problems for these campaigns or the committees themselves?
So it's the paperwork is, to put it mildly, substantial, as it should be, but it's hard to, particularly in cases like you're running for congressional office in a particular state. Sometimes you're required to file both with the Federal Election Commission in DC as well as with the state's governing body here at the Pennsylvania Department of State. In just even state races and state and local races, for example, people who are running for judicial office here in Philadelphia sometimes are required to file with the city as well as with the state, even though being a judge, for example, the Court of Common Pleas of Philadelphia County is a state position, but you're only running within the county. You would have your paperwork is governed both by city statute and state statute. So, and sometimes some counties permit you to file the state paperwork both with the state and with the county. Other counties have, of course, their own paperwork, their own filing that you have to file with them as well.
David, let me ask you then, what about the investigation or enforcement process on this? When a campaign is accused of violating election law, what does that look like?
So a lot of times that will look like a complaint from someone who's on the outside, who's reviewing the information. It could be from your opponent, right, has reviewed your filings, and they will call the governing body, usually either a state ethics commission, the Department of State, the city has an ethics commission. They also have 3-member election commission. And so anybody can make the complaint. A lot of times what you'll see is candidates are habitually late in filing, right? Particularly candidates who don't have assistance from someone who does this all the time. They're habitually late in filing. That will, generate letters from the governing body, whoever it is, state, local, federal. And then a lot of times what happens is once you're late, it's like when you were in high school, right? You turned in your homework late, then the teacher's watching you the rest of the semester, right? Like a hawk. So sometimes if you're late, that triggers a more specific review of what you do file. So, even though the penalty for filing late might be a fine that's not that much money, you're then trading that for being watched for the rest of the campaign cycle.
So in that vein, then, what proactive steps can political parties or these action committees, in terms of planning for the next election cycle, we're winding down here in 25, going into 26, what steps can they take to stay compliant from the start?
I would say hiring initially a good finance director, just an individual who's going to help you basically keep the books, right? Then once that individual is on board and you start actually collecting money, the hiring of a firm that can do compliance work, right? There are firms, there are people within law firms that do it, but there are also just firms that do compliance work, right? In other words, it's like being an accountant for a campaign, except they call it campaign compliance firms, not accounting firms. But essentially, they're going to make sure that the forms are filled out, right? That everything's in order. They're going to present it to the candidate or the head of the pack for review, and that person is going to sign off on it. And they not only have the skill and wherewithal to look down your finance director's, for example, list of contributors and be able to mark it up, redline and say like, hey, we shouldn't have taken any money from ABC Incorporated because we're not allowed to take corporate checks, right? And that will have to be returned. And then they have sort of the technical know-how. They have the software that prepares the reports so that you're not sitting there filling out these, mammoth size reports with a pen, right? You're doing it on a computer, on a spreadsheet, and it's being produced for you in a format that can be properly uploaded to the state or whatever agency you're uploading it to.
And finally, David, as we land the plane on this episode, how can legal counsel add value to these campaigns and committees beyond the simple compliance part?
So compliance is one, but also preparation of campaign materials. Everybody has seen the paper mailers that you get, and it says at the bottom, paid for by, that is a very important part of the law. Frequently, as we get closer to election day, sometimes you'll get mail that doesn't say paid for by. And if that's being sent around by your opponent or in the name of your opponent, you can actually go to court and get that stuff withdrawn. You can get posters taken down, billboards taken down. You can get injunctions against that kind of not only written advertising, but even television advertising, because I'm sure everybody knows, like at the end of a TV commercial, somebody's talking really fast about, reading all the required statements. Those commercials can come down if they don't have them or they're not written across the bottom. So there's that. And then finally, you can have somebody, we didn't really talk about this, but you can have somebody incorporate the campaign so the candidate isn't personally liable for any debts. You can have insurance against being sued for slander or libel. All these kind of sort of small business type issues face campaigns in the same way they face small businesses. So you can get that same kind of counseling from an attorney on those issues as well.
Yeah. David, thanks for the time and insights on this. Truly appreciate it as always.
Thanks, Mike. It was good to be here. Love talking about this topic.
And I love listening about it. And thank you to everybody out there listening to today's episode of Strategic Justice in Action with David Senoff. Look, if you're involved with a campaign, political party, or a political action committee right now, you want to make sure you're meeting all of the legal requirements. Do me a favor, visit firstlawstrategy.com to connect with David and the team. Be sure to like, subscribe, leave a review and comment, or share this episode with someone who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.